Brad Williams, Labor Compliance Group. Here's another civil wage penalty assessment. And I'm going to title it, The 5 Things You Never Want to Do on a DIR Project. I'll try to make this short and sweet. I'm not going to go into the meat and potatoes here. I'm going to point out the 5 things that you, as a contractor, subcontractor, should be aware of. And what's interesting about this particular discussion are a few things you just don't think about. We have a contractor, Silver Creek. They did some things. All right, I guess they were moving some temporary modular projects for a school district. Problem number 1. Did they pay their workers the proper prevailing wages? No. Did they misclassify workers? Yes. Did they fail to appear at the conference, pre-hearing conference? No. Did they show up at the second pre-hearing conference? No. Did the company do something a little awkward? The company filed Chapter 11 and is submitting its Chapter 7 plan to dissolve the company. They filed bankruptcy. That's number 3. There's no automatic stay in bankruptcy proceedings where a government entity such as DLSE seeks to enforce its police or regulatory power, in this case, the California Prevailing Wage Law. I'm not a lawyer. I'm just acting as a messenger here. In this case, you're not waived. You still need to defend why you underpaid your workers. There's also a requirement about the failure of any party to appear at a duly noticed hearing. In the event that you don't show up, the hearing officer can proceed in the party's absence and may recommend whatever decision is warranted by the available evidence, including any lawful inferences that can be drawn from absence of proof by the non-appearing party. Doesn't matter if you're filing bankruptcy, you still need to show up. The project, and I've stated this over and over and again, if you need to get a better understanding of the timelines relating to the end of a project, DIR's timeline, they have 18 months to file a complaint based on a bunch of different criteria. In this particular case, the awarding body accepted Silver Creek's proposal for the project, and then what's critical here is the recorded date of notice of completion was February 2nd, 2021. From that date, DIR's clock ticks for 18 months. However, if there is a request for information to the awarding agent, in this case it was the school district, they delayed sending out that particular requirements, then DLSE has wiggle room. Because the awarding agent failed to provide DIR their information on a timely basis, there's a word, it's called tolling, which allowed DIR to continue this. The awarding agent was 158 days late in providing the information, the notice of completion, to DIR. So there was a tolling period. The assessment. The complaint alleged Silver Creek misclassified workers. There's number 4. You can't misclassify workers. You can't underpay workers in various trades. What happened? You always have this fallback, and that is classify workers as laborers, always underpay them. The proper classification was house mover, carpenter, iron worker, and inside wireman. Lastly, number 5, don't have a prior history of violation. If you have a history, if DIR's knocked on your door once, they keep a closer rein on you in terms of your performance on future projects. Subsequently, if there's a second or third complaint, the awarding body is going to hit you significantly harder in terms of penalties. In regards to this assessment, as I mentioned, Roman issued the assessment on September 14, 2022. This is just purely for clarification. This was more than 18 months after the awarding body filed the notice of completion on February 2nd, 2021. According to Roman, the awarding body delayed providing DLSE with the notice of completion from June 26, 2021 until November 30th, 2021, a total of 158 days. The delay extended the time within which to serve the assessment until January 7th, 2023. Subsequently, the complaint kept rolling along. Moving on, this is standard language. You can read this on your own. I'll leave a link below. where you can read this if you want to. In the end, DLSE determined that Silver Creek misclassified several workers and underpaid prevailing wages in the amount calculated. Just for a side note, DIR can assess anywhere from $40 to $200 per penalty. If it's a first-time offense, it's $40. The second time, it's $80. The third time, it's $200. In the end, the bottom line here is Silver Creek is liable. They're also liable for liquidated damages. And if you want to read up on that, I have plenty of videos or discussions. In the end, Silver Creek violated those 5 areas that DIR is going to hit you hard. Underpaid prevailing wages, penalties for misclassification, and then liquidated damages of $25,000. Now here's the deal. DIR has hundreds and hundreds of cases open right now for violations or possible violations and complaints. Because this is an ongoing occurrence, and I have hundreds and hundreds of newsletters that I've sent out over the last 10 plus years, and it's the same pattern over and over again. I offer courses on my website. If you go to laborcompliancegroup.com, I have courses. For $277. This used to be a $750 course. It's all online now. It addresses everything I discuss. Under that Chapter 11 and Chapter 7 deal, that's something new. But everything else, 99% of the information that I cover in these videos is available right here. $277. Take a look. Then, if you're somewhat versed in terms of DIR, I have this prevailing wage FAQ. If you're doing anything in San Francisco, you need to be aware of local hire. And if you're doing a Davis-Bacon project, this is a simple contractor's guide, very helpful. So comment, let me know your areas of concern. Also, in February, I just threw in a curveball. I introduced retirement planning. Let me know if that's of interest. Brad Williams, Labor Compliance Group. Thanks for watching. Hope that helped. See you soon.